everyone, and welcome to this Federalist Society virtual event. My name is Emily Manning, and I'm the Deputy Director of Strategic Partnerships here at the Federalist Society. Today, we're excited to host an IHC update on protecting your company from the inside, analyzing new administration policies, opposing state AG policies, and internal pressures. We have an excellent panel today, moderated by Kellen Dwyer, who is currently partner at Holtzman Vogel and is the former Deputy Assistant General for the DOJ's National Security Division and former Assistant U.S. Attorney for the Eastern District of Virginia. After our speakers give their opening remarks, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, thank you for joining us today. And Kellen, the floor is yours.
Thanks, Emily. Thanks, everyone. We've got a great panel today. I'll do very quick introductions and jump into it. We have Jonathan Fahey, who's a partner at Holtzman Vogel and is the former acting director of ICE under the first Trump administration, as well as an AUSA for many years before that. Joe Moreno, who is the general counsel of SAP National Security Services, who will give us the in-house perspective, and Mark Pinkert, who's also a partner at Holtzman Vogel, previously did multiple clerkships, big law litigation experience, and now litigates a number of these constitutional and enforcement actions. Jumping into it, the purpose of this panel is really not to have a normative discussion. I think that a lot of people have very strong views on the Trump administration and DEI and so forth, and there's no shortage of opinion pieces on that. But what we really wanted to do is kind of talk from the perspective of a apolitical, practical in-house counsel who's really just looking to protect their company from liability and from reputational risk, and think through kind of how to predict and analyze the enforcement trends and priorities, both at the federal and state level right now, particularly as it relates to DEI, and think through kind of practically how companies should be handling this to minimize risk. So why don't we start with you, Mark? Maybe just set the table and give us a sense of what the current enforcement trends are and kind of what it says about the larger issues in administrative law and executive power.
Sure. Thanks, Kellen. So there are three broader trends that I think we should talk about to set the table today, and that will be relevant to corporate counsel as they're thinking about navigating these pretty rapid changes in policy. But I think big picture first, we're very much in an era of expansive and expanding executive power. And we're seeing not only that, but we're seeing major social policies and regulatory reforms via executive order. And on top of that, the executive orders are very sweeping. That is, they're sort of whole of government approaches. And you saw that going back to the Biden administration. Sort of on day one, he came out with climate change executive orders, DEI executive orders that really instructed all of his agencies to get the wheels in motion for these sweeping policy changes. And obviously now Trump is sort of going the other way, rescinding a lot of the orders and also issuing very, very broad and sweeping executive orders that, may cause corporate counsel some whiplash. So I think that is sort of the first thing that we need to think through or have it in the back of our mind during this discussion. It can be very hard for a company to plan in that sort of environment where you're investing in compliance, you're investing in infrastructure, and then within 4 years or everything changes and the rug is brought out from under you. A second trend I think we should have in the back of our mind is this increasing use of enforcement as a means of regulation at the agency level.
Regulation by enforcement.
I'm sorry, what did I say? Enforcement by regulation? Yeah. Regulation by enforcement, excuse me. So, when a president does have a very broad policy agenda, that can be very tough to push through Congress, obviously, but it's also becoming more and more difficult for agencies, I think, to go through the normal rulemaking processes. They've got to do the research and the studies to justify the rules, the impact, the economic impact assessments. And then, on the back end, there are judicial challenges and preliminary injunctions that slow all that down. And so what you've seen in recent years is this effort to regulate by enforcement And what I mean by that, and you look at the Biden administration, his top enforcers like Lena Khan, Gary Gensler at the SEC, I mean, they said explicitly they are going to bring losing cases to court, push the boundaries of the law. But even if they lose, what they've done is essentially deterred the behavior that they don't like just by upping the cost of engaging in that behavior. And so I think that's an important policy if you're corporate counsel, because not only are you needing to look at the laws that govern your business, the regulations that govern your business, the guidance documents, but also you need to know what the enforcement trends are and if these agencies are coming after you next. So that's something to look out for. And I think that's a big challenge for corporate counsel. And then the last trend I'll just mention here is, if you're a multi-state or a multinational business, especially, not only are you aware of what's happening at the federal government, but you are subject to the laws of several jurisdictions, and you're subject to several different enforcers. And so while you may see one policy at the federal level, you might get the polar opposite policy from the state level from an attorney general or a governor who is in the opposite party as the White House. So that's another sort of minefield to navigate. And I think that especially in times of very political polarization, that can make the job of corporate counsel very difficult. So I think all of those trends are important. And I think we'll see that really play out in the DEI context, especially.
Okay, Joe. How's your job changed since January 20th?
Yeah, so at this point in my 2.5 decades of practicing, I'm now looking at about 5 years in the government and 15 years in the law firm world, and I'm coming up on 5 years in-house in my first in-house job. And I think that I would say the job really comes down to a word that Kellen kicked off with, which is what is practical, right? Management wants practical advice. They don't want theoretical advice. They don't want long legal analysis. They want to know what does the law say, or what do we think it says? What are the implications? What are the costs of compliance? What are the implications if we push back? And what happens if the next administration changes its mind and goes to a different direction? And so, I've seen the tail end of the first Trump administration, the entirety of the Biden administration, and now since January 20th, are we at 100 days yet? Maybe just about. So yeah, it's a constant flurry of changing rules and putting aside one's, personal preference, whether you're happy, you're sad, or, about what's happening. It's a lot to keep up with. Right. And again, management doesn't want to know what the theory is. They want to know what to do. And so that's what we struggle with every day.
All right. Well, why don't we get specific then? Let's turn to DEI. I think that is an area where a lot of people, it's obviously a priority for the Trump administration, but it's an area where a lot of companies see the biggest enforcement risk that didn't exist 3 months ago and clearly exists now. So before getting into kind of the practical strategies, I'll turn to John Fahey. What does DEI mean? And I guess kind of the more relevant question is, what does the Trump administration mean when they say they want to eliminate DEI?
Yeah, I think that's a good question, because what DEI means is probably different based on who you ask. But, the words diversity, equity, and inclusion under the Biden administration and certain, I guess, under that administration and others that agree with them, they view DEI as really a way to sort of open the door to sort of level the playing field, to allow everyone to have an opportunity to participate in either, education, career, certain careers within the government, and to enable people to work together, feel comfortable working together, a lot of just that type of thing. The Trump administration views DEI as discrimination, and whether you call it reverse discrimination or whatever, it's basically choosing one group over another group, whether it be in education, and a lot of this, some of this is bolstered by the Supreme Court ruling in 2023 on the Harvard, North Carolina affirmative action case involving the colleges. But it's basically saying that any of these things where you make race paramount, you're necessarily discriminating against people that aren't of the race that's sort of favored or propped up there. So that's basically the big difference is I think at least the way the Biden administration portrayed their view of DEI was it wasn't discriminating. It was just basically giving people opportunities they would otherwise not have. The Trump administration is drawing a line, and and they're also saying it's time to follow the law on this. And you can't discriminate when you hire someone. You can't look at their race. You can't look at anything else other than the merits of their application and how they would perform the job, how they would get promoted, and things like that. And I think we'll get into some of the executive orders, but it certainly permeates from not just within the government, but throughout people that work with the government as contractors, as people doing business in any respect with the government. So it ends up being a very broad impact societally, not just within the federal government.
I thought one point you made earlier when you said the Trump admin basically views when they say DEI, they mean discrimination. And I looked at the executive order in preparing for this, and you'll note in the Trump EO on DEI is not actually defined. He says a couple of times at the beginning, refers to the illegal and immoral discrimination programs going by the name DEI, and later says all discriminatory programs, including illegal DEI, goes on and then adds by whatever name they appear. So discrimination is, I think, the closest we have to the definition. So then I think maybe I'll turn to Mark. The question is, what constitutes discrimination? What are companies supposed to look at when they're trying to figure out what falls within this, what's DEI, what's discrimination, what isn't, and how does the Harvard case play into all of this?
Yeah, so I think actually there's one other aspect of this that's pretty interesting just to add to Jonathan's point, which is I don't think it's just the concept of discrimination. I think when you ask what the Trump administration is trying to eliminate, DEI has really been institutionalized. Again, we may sort of struggle to define it, but in the last 4 or 5 years since George Floyd, the protests since during the Biden administration, there's sort of become a major DEI industry and DEI offices in companies and schools and within the government. I think Michigan, I was reading the other day, had something like 150 DEI administrators. So it's not really just a concept of discrimination or affirmative action. I think it's actually a series of institutions and offices and personnel that the Trump administration is trying to eliminate and trying to sort of excise from American society, not just, like Jonathan said, in the public sector and in government, but in the private sector as well. You mentioned the SFFA case, the Harvard admissions case, and how that plays in. That's obviously an important inflection point in this entire discussion, because there the Supreme Court held that Harvard and UNC's admission policies were unconstitutional to the extent that they considered race as a factor. Now, because it's a 14th Amendment case, the court applied the facts to the sort of strict scrutiny analysis. So I think technically you might have a set of facts where you have a compelling government interest in a race-based admissions or hiring policy that could satisfy the strict scrutiny inquiry. But I think the court was pretty clear in its direction. And Chief Justice Roberts said, look, if you want to end discrimination in society, you have to end all forms of it. And so whether or not it's, discrimination in favor of historically discriminated against groups, or it's reverse discrimination, or whatever it is, I think the court is trending towards ending all of that. And one other point on that is there's currently a case in front of the Supreme Court under Title VII. It's called Ames, and that's dealing with the standard that a member of a majority group has to satisfy to bring a quote unquote reverse discrimination case. So we may see when that decision.
How do we think that's going to come out?
Well, I think it was a short oral argument, and I think the court actually probably not just the conservative justices, but I think maybe 7 or 8 or maybe even unanimous would come out in favor of the plaintiff in that case. There was a circuit split, and several circuits that actually held that if you are a white male or a member of a majority group, you actually, to prove discrimination, have a higher burden. And I think that it's pretty clear the court, at least 5 justices, maybe more, would rule that everyone has to play sort of by the same rules in court.
Real
Okay.
quick, Mark, sorry to interrupt, but
Please.
do you view sort of the Trump administration's executive orders and approach to this are in some ways complying with what the law is on the Harvard case and what they expect it to evolve in, essentially saying we are running within our government a massive discriminatory scheme, much like Harvard was and much like North Carolina was, or at least what the Supreme Court found. So they may, in fact, just, there's certainly a good argument that they're just trying to get in line with what the law is and how they expect it will evolve from that case.
I mean, I think that's a great point, and I definitely think that is a good argument for the Trump administration. I think opponents of the decision would say that it hasn't been extended yet to the Title VII context and to the workplace. It hasn't been extended outside of the admissions context by the Supreme Court, at least. And so there's still some open questions. And in fact, the Supreme Court in the Harvard case left open affirmative action in military academies and did not take up a case dealing with West Point. So, it's possible that there, still some wiggle room in that space. But I think, again, reading the tea leaves, I think the court was pretty clear on which direction it's heading in terms of what, the 14th Amendment Equal Protection Clause means for everyone in the workplace environment, in the government, under Title VI for federally funded programs. So, yeah, I certainly think that's true, but there's still some open questions.
Great. And then going back to John Fahey, can you tell us more on the executive order on DEI? Can you tell us sort of what entities that applies to directly, and then relatedly, kind of what the Trump administration has done so far in terms of investigations on DEI, which would sort of reach more directly into the private sector?
Well, there's basically three relevant DEI executive orders. One that involved the government, the second that involved the private sector, and the third that involved military academies. And just the first one involving the government is ending all DEI in government. And it specifically reversed a Biden DEI, or replaced a Biden executive order on DEI, that it was all about advancing racial equity and things like that on the DEI front. But the first executive order, it affects it within the government, meaning any and all DEI positions are terminated, and they can't change the name to call DEI something else. Mm-hmm. And the other thing is they have a provision in there for employees to alert supervisors if there are ongoing DEI practices.
Whistleblower, inviting whistleblowers, so to speak.
Yeah, when they're sort of trying to hide people. And they view this, again, sort of back from the initial part, is part of it's the discrimination, and part of this they talk about is just part of the overall Trump administration focus on waste in the government, and they view these programs as wasteful. But the first one extends out into the private sector in that it affects, which Mark talked about earlier, sort of this DEI industry that's out there that, if you probably add it all up, it's probably been about $1 trillion industry if you add how companies have had to import it and everything else. But basically any contracts with contractors that involve DEI, maybe DEI training and things like that, are all canceled under the first order. So that's the first order, is government. The second order is the one that is more impactful probably on people like Joe and other companies, and a couple things that I think stand out. But basically it eliminates DEI, or seeks to eliminate DEI more broadly in organizations, publicly traded companies, educational institutes, things like that. Basically any contractors doing business with the government have to certify they're not using DEI. This one is the one that revoked Lyndon Johnson had what I think it may have been the first time the affirmative action standard was discussed in the 1960s, that basically there was supposed to be affirmative action in contractors to make sure they're not discriminating or to favor minority groups. So this reversed that, which is 50 plus years old.
And sorry to interrupt the court. Sorry to interrupt. The court just actually paused that, I think, yesterday or the day before. So the certification requirement. So
okay.
a lot more legal challenges. Sorry to interrupt you.
Oh yeah, no, that's good to know. You're more on top of this. But there's a couple things that are impactful that basically this requires the Attorney General to compile a report within 120 days. And I think this was issued 21st, 22nd, somewhere around there of January. So we're looking at maybe within another month that each agency must identify the most egregious violators in each sector in which they operate, meaning these could be private companies or institutions. And they're also supposed to identify up to 9 sort of bad actors that are most egregious violators for investigation, for government investigation into their DEI practices. So this is important in that, and then it also talks about DOJ ultimately enforcing DEI or non-DEI laws or discriminatory laws that basically are still doing DEI. This would be probably under Title VII or other areas. But why it's important is, each agency is going to have to identify institutions to investigate, which puts a lot of pressure on whether it's a company like Joe's, whether it's a nonprofit, whether it's a college or anything like that. And they specifically talk about publicly traded companies or things of higher dollar amounts. They do higher volume in terms of revenue. So this puts a lot of pressure on companies as to, one, if you're getting rid of your DEI, how do you do it? Do you do it in a way that you just change the names that could create problems? How do you do it? And also, whenever you're being investigated by the government, it's important. There's a lot of times there's communication on both sides to be able to communicate to the government, whichever agency is investigating, how you have interpreted the orders and how you have acted in good faith to implement these orders within the framework of whatever you're operating, because that could go a long way in terms of how they intend to focus or who they intend to focus on and how they intend to focus on. So it's important for anyone out there to look at these orders and see how it affects their business, how they could comply, and how they can also show that they complied if they end up in a situation where they're having discussions with the government. And
all right. Go ahead.
No, I think that there were some company, you were asking which companies were already involved.
Oh, yeah. And what actual investigative activity have we seen out of the Trump administration so far on DEI?
I think what we have, I think there is an investigation on, what is it, Mark? Is it Disney? They've opened up an investigation.
And ABC, the FCC, I think, is looking into them. The Department of Education, obviously, several schools, and everyone sort of knows what's going on there.
Law firms
as well. The EEOC has requested information from, I think, 50 or more law firms. So things are underway. I don't know that DOJ Civil Rights has done anything just yet, but maybe they're next in line.
They recently got a confirmed AAG, so I'd expect to start seeing some activity out of there pretty quick. All right, well then we'll stay with you, Mark, just on the state piece. So in addition to the federal government, companies need to worry about state AGs, which have grown increasingly powerful and increasingly, we'll say, activist, I think, on both sides in recent years, for better or worse. What can you tell us about what the red state AGs are doing on DEI?
Yeah, so in a lot of ways, although the federal government is getting a lot more of the media attention, I think companies ought to be focused on what state AGs are doing, and red state AGs especially, because in some ways they can work even quicker than the federal government. After the Harvard admissions decision came down, several state attorneys general sent letters to large companies within their states, basically saying NDEI. This decision basically makes it unlawful. 19 state AGs sent a letter to Costco, trying to get them to do the same. So there have been those sorts of initial outreach and letters and things like that. I think the most notable action that I'm aware of, at least, is the Florida Attorney General recently sued Target, not under anti-discrimination sort of theory, but arguing that Target had misled its investors by failing to disclose the risk of its own DEI policies. And in that case, it's the Florida Pension Board or the Retirement Board, which owns shares in Target. And so is bringing the state AG is bringing the lawsuit under federal securities law. So that can be sort of a model for state AGs where there are statewide pension funds and things like that invest in companies with DEI, and where they're like with Target had boycotts or Bud Light or something like that.
So the theory is there was a risk that your sort of aggressive DEI policies were going to alienate your customers, and you either minimized it or didn't fully disclose it, and then we got a security suit.
Exactly. So that's the theory, and again, I think that could be a model for red state AGs. I mean, but that state AGs have a lot of other tools in their tool belt. They have consumer protection laws. They have employment and state discrimination laws or anti-discrimination laws. They have unfair trade practices and state securities laws. So I think there are a lot of creative ways that state AGs could get involved, and I think they're probably pretty eager to do so. And they'll move quickly. So that's an area, if you're a corporate counsel, not just following what's happening at the federal government, but keeping a close eye on what's happening at the state level.
All right. Well, let's get Joe Marino back involved. What are the practical steps that companies, can take or have been taking to reduce the risk here in terms of facing DEI enforcement from either side? And what steps have you done, or what steps would you recommend?
Yeah. So just going back to some of the resources that Mark referenced earlier, definitely look at the executive orders. But there is a OPM memo from February 5th. That gets into a little more detail in terms of, it doesn't define DEI still, but it does, to your point, it ties discrimination to DEI. And it talks about taking actions motivated by protected characteristics. Now, these are obviously applied to government agencies, not private companies, but it gives you a kind of a view into how they're viewing all of these kinds of things. And
for those of us who don't know, OPM is
Office of Personnel Management. Right.
So in a White House office.
Yeah. HR, universal HR department that kind of trickles down rules to the individual civilian agencies. And so it's only 3 pages, but I definitely recommend taking a look at it. And it makes the point that what it considers unlawful discrimination is not limited to recruiting. It also extends to promoting. It extends to providing opportunities. It extends to professional development programs that are only available to certain categories of individuals. And so extrapolating from that, I think, can give you a good sense of how what this administration views as appropriate versus not appropriate. If you are in the government contracting area, and John touched on this, at this point, you can expect soon to start receiving requests to certify in your government contracts as to whether or not you do certain things. And one thing that you may have seen is the requirement to represent that you do not operate illegal DEI programs. Now, that's not, again, really well defined. So you have to kind of extrapolate, what does it mean to operate and what does it mean to be a DEI program? Mm-hmm. And if you're a prime contractor or if you're a subcontractor, these will start trickling down to you. And so that has generated a lot of discussion about what does that actually mean? Is there any flexibility in these representations that you can try to push back on? But that's kind of the focus where I've seen, that's the operative, is that do you operate DEI programs? And even if you could say you do not have any kind of quotas or specific recruiting targets or metrics that you maintain to maintain certain ratios of different protected classes that you hire or promote, what about things like women's professional mentoring groups, right? What about things like other groups that may or may not even be limited to certain characteristics of people, but are focused toward those characteristics? Does that toe the line? Or is a professional development type program Does that veer into what would be considered an unlawful discriminatory DEI program, or is that okay? And so,
and what should you do if you're a government contractor? And is it just to click yes or no? I operate in a legal DEI program. I don't, or should you try to give a narrative to try to explain very clearly, what you've done and what you haven't done?
Depends exactly what they're trying to get you to do. If it's a representation it's a rider to a contract, you may have a situation where you could try to propose different language and go back to them. If it's a portal where you basically have a yes or no option and there's no room to leave notes or negotiate what is actually meant in that yes or no response, that gets a little trickier.
Mm-hmm. Do you think, Joe, just following up, when you're talking about at the beginning being like sort of the practical advice versus sort of the legal advice, and you're talking about pushing back, is there also sort of that practical advice pushing back might be to your disadvantage in terms of getting new contracts and things like that versus affirmatively and proactively stating what you've done to comply with these new orders and how you've made adjustments and believe you're in compliance?
Well, I guess it depends on how far you believe that you've gone down some of these like rabbit holes and how much you have to kind of, sort of back out your prior positions. If you're comfortable that you did not have these kinds of programs that you think the administration is looking at, well, then you're in a better position, obviously. And you have to kind of look at around the edges, things like I said, employee resource groups, things that be completely well-intentioned and were never intended to be discriminatory, but yet do you feel like you have to change those? Even things like, do you avoid the use of the words diversity, inclusion in your website? In like, how hypersensitive do you want to be in terms of anticipating what could antagonize the administration? But at the same time, you have to realize that these concepts are very important to people, and that kind of veers into the practical, right? We can give legal advice all day long, but management also wants to know how are employees going to react to some of this stuff, particularly employees on the junior side of things, people early in their professional careers. You're kind of juggling what we know about what the administration wants, what we anticipate the administration may want based on the gaps that they're leaving, and then the ramifications of like how far do you go and what happens with the pushback that you get from people at different places in the company.
Can I just follow up there on just two things? One is you made a great point about how your employees are going to handle that, but I also think if you're a major corporation, you also have to look at your consumers, and if they see that, okay, well, you're sort of caving and giving up on DEI, you might get boycotts from the other side. So I think that's a risk that you'd have to factor in as corporate counsel advising your board. But I did want to ask you another question, which I think goes back to Kellen's point at the beginning, that people do feel very strongly one way or the other about DEI typically. And if you're a company that's hired a bunch of people to fill out a DEI office, and they have titles like head of DEI or assistant DEI chief or whatever, they obviously have strong views about that viewpoint and that policy. What do you do now in terms of, do you just give them a new title? Are you concerned that they're going to continue to try to promote those policies within the company, and then you're in the government crosshairs anyways? If you fire them, then you're looking at lawsuits from them. So how do you deal with the sort of personnel issues? I think personnel is policy, and just giving people new titles probably doesn't solve the problem.
No, it doesn't. I think you have to, and again, this kind of goes into a bit of sort of guesswork, is like, okay, what do we really believe is not tolerable to this administration, and what is? And can the very well-intentioned actions or obligations or duties of certain employees, can they be retooled in a different way? Can an internal mentoring program that is available to everyone, regardless of your personal characteristics and regardless of what point in your career you are, or maybe it is for more junior folks and they have one for more senior folks. I think there's many, many ways you could reuse the talent that you have without completely just discarding them. And so I think that, but again, there's some guesswork there, and down to, again, like I said, like the use of the words, which may have a completely benign, completely and very well-intentioned meaning. But if you think the words are close enough to the kinds of words being used in these executive orders or in this OPM memo, you might want to say, yeah, we should stay away from those.
Yeah, and meanwhile, the blue state AGs aren't just going to sit on their hands. So what are the sort of the risks coming from the other direction that if you move too aggressively to eliminate DEI, what risks are you facing either from plaintiffs' lawyers or from blue state AGs? Open to the floor, anyone who wants to jump in on that.
Well, no, I mean, I think you said it. I think, blue state AGs are going to be looking to make a statement and sort of be part of the resistance to Trump too. You also will have a potentially new administration in a few years. So I think, again, that's why this area really is a minefield. They're not clear legal answers. I think the answers are actually very, to Joe's point, you have to be practical and you have to understand the political landscape. And that's a challenge for corporate counsel. It takes, a very broad set of strategic skills to think, how do you navigate and how do you direct the business? Because following the law to the letter is going to create all kinds of other risks from the other side, from plaintiffs' lawyers, from your consumers who might boycott you, from blue state AGs, and then the next administration.
Right. And I should remind the listeners, we are taking questions for anybody who wants to type in. We have one very specific question from Mark. We'll put him on the spot. A viewer wants to know what circuit, case name, not case number, circuit and case name for the case yesterday that halted the resuming of the certification requirement for contracts.
Can't remember exactly. I want to say National Association of Diversity Officers in Higher Education versus Trump, 2025 Westlaw 57376, District of Maryland, February.
There you go. I was confident you'd be able to pull that out. Well, I'll give you guys a chance. If anybody wants to chime in with anything else on DEI, FedSoc has kind of volunteered us to cover a few more topics, so I'll try to get those
Let me just throw one out to Mark or Joe or Kellen. What about like shareholder derivative suits? Is there potential on that? And sort of, it is this weird world that you're talking about. You could theoretically have state laws that are arguably colliding with these executive orders. But has there been any activity or rumblings about that with these orders?
Yeah, I mean, I think with plaintiff lawyers are always looking at what state AGs are doing around the country, and vice versa. And so you often get follow-on lawsuits. So with the Target lawsuit, for example, the Florida AG is bringing that as an investor and shareholder in Target through its state pension. So I suspect that you would see private follow-on lawsuits. And again, I think the problem here is these can sort of go in either direction. So, I keep stressing this, but I think it's a really difficult area to navigate. So, the threats are coming from all sides, and I do think inevitably you will see, class actions and things like that.
I think you could see a pretty similar theory that the Florida AG used against Target as a securities matter. You could kind of repurpose that into shareholder derivative pretty simply, right? The theory would be that your obligation was to maximize shareholder value. Instead, you tried to bring in, various sort of political activism, and it cost us shareholder value. And,
Yeah, but the same thing is true if you get rid of DEI and then you lose all your consumers in New York and Illinois, and you get boycotts.
Totally. All right. Last words on DEI.
Joe, my overall take on it is sort of what the companies, I don't know Joe's take, but we've seen a lot of these companies over the past 10 years or so, particularly up and around sort of the George Floyd era, that were putting their neck out there on political issues in a pretty aggressive way. And I sort of expect whichever way they come out, they're going to be less forward-leaning politically, because it was safe to do it 5 years ago if you were at least one side of the political aisle, meaning the left side, but it just now seems high risk. And I think a lot of the companies are going to really rein a lot of that stuff in, whether it's activism type of giving and things like that. Joe, have you seen that, or is that in your world?
I think it's wise in general to tread very lightly in political issues, but especially when you've seen the sort of zigzag between administrations and how, who knows what's going to happen in 3.5 more years. So you could have a very different administration then. So I do think that at this point, it is smart to tread lightly in terms of hot button issues and sticking your neck out. And I think it's, this might sound cliche, but it's good to find a moderate position, find a reasonable moderate position. And you're not going to make everybody happy all the time, but try to find a situation where you're not going so far in one direction that you have to kind of then pull back because the political winds in Washington have changed.
Yeah, and most people are investing their money to make money, not to advance political causes. So it always runs the risk of not only offending consumers, but also your own investors that are investing their hard-earned money, possibly their retirement, and may not agree with these particular causes.
It's not a perfect parallel, but I mean, that's happening to law firms now. I mean, law firms that very prominently took on, cases or individuals from one side of the aisle or the other, and may have refused one side or the other, and now it's kind of being taken out on them. And again, is it more important to make a political statement, or is it more important to get paying clients who trust you because you'll represent them regardless of your political leanings?
We have a user question. Someone asks, when should we expect the EEOC to provide employers with guidance similar to OPM on how best to remove discriminatory practices from current employer DEI initiatives? Joe, you want to speculate on that one?
I don't know the answer. It would be wonderful to get that answer, to find out some kind of guidance like that, as opposed to a lot of guesswork that's happening right now. And that would be
All right. Well, we originally kind of focused this on DEI, but Federalist Society kind of wanted to make it broader in terms of enforcement trends. So they asked us to weigh in on FARA and FCPA. So I will call my own number here on FARA, which is the Foreign Agents Registration Act, which is enforced by the National Security Division, where I used to work. There's a very long history to it, and there's been a lot written just specifically on FARA, so I'll try to just give the 2-minute overview. FARA is a law which makes it a crime to fail to register with the Attorney General willfully if you are an agent of a foreign principal and you engage in, quote, political activities within the United States on behalf of that principal, or act as the foreign principal's, quote, public relations counsel, publicity agent, information service employee, or political consultant. This is a statute that was passed in 1938 and essentially laid dormant for however many years until 2016. And after the 2016 election, you had a DOJ IG report, which sort of looked at foreign interference in elections and hammered DOJ, particularly National Security Division, for having the statute, which is geared towards that and not acting on it and not using it enough. So DOJ kind of swung into gear and brought a record number of cases under FARA. Many people, certainly including the new Trump administration, feel that they went way too far with that. So you had a memo from Pam Bondi, I believe the night she was confirmed, which only addressed a number of topics. It only addressed FARA in about 2 sentences, but it says in FARA that they will only use criminal charges to enforce FARA in instances of alleged conduct similar to more traditional espionage by foreign government actors. And I think that was fairly, widely criticized as what does that mean? And a lot of people who are sort of in the FARA space saying, well, FARA is about foreign influence, whereas espionage is about stealing information. So these are totally different. But I at least think it's fairly clear what that means if you're not too formalistic about it. I think the DOJ is focusing on foreign influence activities on behalf of nation states, or at least their equivalents, whereas FARA applies to any sort of lobbying activity on behalf of foreign individuals or companies. And most of that is really pretty far afield from traditional espionage or traditional, national security concerns. So they're not looking to bring criminal charges there. And the way I sort of look at it is, if you're looking at a FARA charge, is this someone who didn't, could have registered with the AG but didn't for whatever reason? Or is this a situation where, of course, they couldn't register? And by that, I mean, if you're in the country to be a propagandist for Hamas, like, it's not just that you failed to do the paperwork. It's that if you had registered, we would immediately, if you don't have citizenship, kick you out of the country. So you couldn't do it, or if you're here for the Chinese or so forth. So I would look for those sorts of things to be when you're going to see FARA enforcement. And then the second question that we get a lot from private individuals is, does this mean if I'm not in that space, I'm not working for the Chinese, I'm not working for Hamas, do I not have to worry about registering? And I wouldn't be so sure. I think FARA is a statute which lends itself to abuse. It is just so extraordinarily broad, covering anyone who's doing anything related to public relations or influencing policy or politics on behalf of any foreign person. And it's by its nature, it's the people who it's targeting are people who are in the political sphere. So if you're in the political sphere in one way or another, you could have enemies in government, either in this administration or the next. So I would very much recommend dotting your I's and crossing your T's on FARA, even if we have this memo saying that the DOJ is not going to be as aggressive on it.
I have a question on FARA, Kellen.
Sure.
If you had the instance where maybe it was somebody, Hamas, that's going to get kicked out, but if somebody is operating who's a United States citizen and they register on behalf of a foreign organization or foreign government, what can the DOJ reject that request, prevent them from doing so after they register? I guess my question is,
Sure.
is there a downside even under the new scheme to just registering anyway, like you said, dotting your I's and crossing your T's? And is there upside to laying low?
So, Hamas is a foreign terrorist organization. So if you disclose, engaging in any sort of transaction with them, you're admitting to a different crime. So that's what I mean.
What if it's somebody that's not quite Hamas, but
Sure.
just something that you might not? Is there, I guess, the advantage to registering even now, or the disadvantage to registering?
Oh, right. So if you are a, fairly normal lobbyist, right? And you have, or even if you don't call yourself a lobbyist, because it's not just limited to lobbyists, if you're engaging in any sort of public relations, think tank, advocacy group, and so forth, if you're working on behalf of foreign entities, you do need to do a FARA analysis. And what's the downside of registering in a close call? Not that much. It's annoying. You have paperwork requirements to keep. I think a lot of people don't like the stigma of it.
Is it more of a stigmatization?
I think for most clients I've dealt with, that's the biggest thing. When I say, let's register, and they normally take my advice, but some of them will say, well, geez, by your nature, these are people who are public people, right? They might want to at some point go into government. They might want to, do various public facing things that it might not sound good to say, well, I was a registered agent for the Emiratis and so forth. I mean, even I think Pam Bondi was registered under FARA as a lobbyist on behalf of a few foreign entities. And that was sort of used against her in her confirmation process, even though she's just following the law and a totally appropriate thing to do.
So the DOJ doesn't think there's anything wrong, that doesn't open them up to, other than attention they might get, there's nothing,
nothing wrong with it, but of course they're gonna, if it's more suspect, they might keep a closer eye on someone. So if someone's actually working on behalf of the Chinese government and they're here to kind of promote pro-authoritarian ideas and they register that, DOJ might start taking, that itself is not a crime, but they might start taking a hard look at you for other things. And so
is your take on sort of and I know it's only a few lines in the memo, but is it really just kind of taking it back to the pre-2016 world of FARA, or is it more severe than that, this change?
Yeah, no, I think going back to pre-2016 is, there's only 7 prosecutions between 1938 and 2016. So that would be pretty far, taking it back pretty far. I don't know that they're going to go that far. I mean, frankly, for the people that were concerned about the Trump DOJ going after political enemies, they should be happy with the Bondi memo on this because, I mean, FARA is the number one tool that if one wanted to go after their political enemies, it, is an extraordinarily broad rule that could clearly be used to do so. So I think that's something that people should be generally encouraged about if that's what you're concerned about. But, can I say FARA? I mean, that's what will never be used. It's kind of hard to say because, I mean, prosecutors like to have tools, right? Prosecutors like to keep the broadest tools they can possibly use because even if they in general think FARA is used too much, there might come a target who they think,
right. So even
really deserves it
to bring it back, that it doesn't.
I think
preclude DOJ
like with any federal criminal law, if you have a bad enough target, and by bad I mean just someone who we can all agree is someone who should be prosecuted, the temptation to use the broad laws to do so is certainly there, and there's nothing in the memo that, it's just an internal memo, doesn't stop the prosecutors from doing it if they get internal approval. Mark, you look like you want to jump in.
No, just interested in everything you had to say.
All right, we've got a couple minutes. Maybe we turn to FCPA, which again, there's FCPA is its own entire practice area. I know there's been a lot written on this, but maybe we'll just go to Fahey real quick because you're so plugged in with the administration. What do we see happening with FCPA? Is FCPA no longer a thing? Is it going to be repurposed for other priorities? Where do you see this going?
It seems like it's almost in the same world as sort of the FARA world because the FCPA over the last, 20 years or so, I think from 2004 to recently, I think the number of cases was like 1,000% higher than it had been the previous. The law was enacted in 1977. So the first sort of half or so of the law, there weren't very many cases. And then it really, sort of exploded as sort of an industry in and of itself, both on the private side and within the government. But I think this one, what I see the purpose of, and just for people listening, they basically have suspended doing FCPA cases and there's like a 180-day pause on them, and they're reevaluating cases. And the view, I believe the administration, they talk about it when they did this, is they believe that FCPA was putting American companies at a competitive disadvantage to some foreign companies because the FCPA prohibits bribery of foreign officials by American companies. And this could be problematic, not that the administration wants our companies bribing foreign officials, but in certain countries, if that's the way that business is conducted, then American companies may be shut out of business opportunities, but also that they view this as affecting national security because if you're not able to engage in business in certain parts of the world, you have less of an ability to exert influence, to know what's going on there and things like that. So I think they view this sort of as it was overused, and secondarily as, hey, we are a new administration and we are pro-business, pro-American business, and we don't want to do anything that would discourage a company from locating in the United States, from starting in the United States. And if they do, we don't want them to have a competitive disadvantage overseas. So I think that part of it is interesting. And the other part of it, for businesses, the FCPA was very expensive in terms of compliance because, the incentives were for businesses, if they had some issues, to report them to the government, to work out some settlements, to work out compliance programs, which cost a lot of money, and attorneys' fees and things like that. So I think this, a lot of ways is very pro-business, and also a reaction to it maybe being overused. And so I think I expect, even after I think it's a 180-day pause, that the general policy will remain in effect, that it won't be prosecuted that often. And this kind of fits into some of his initial comments of what's practical, what's legal, and how do you advise your client, whether you're in-house counsel or outside counsel, because you see a lot of things online since the change in policy, which was, coming out from law firms, and this may not just I'm not sure what the most practical advice is, but a lot of the advice has been don't do anything different, keep doing the same thing. And that may not be the most practical advice to be giving a corporation because what they've been doing has been quite expensive. So there may be a way to, you're not saying go out and bribe people, but can we, eliminate some of the cost of compliance so we can focus on other things that advance the interests of the business and advance the interests of the shareholders. So, but I think it's sort of in the same, world of the Pharaoh stuff, but I think this one has a sort of a more America first, pro-business approach to it. I think that's what, and some people have viewed the FCPA as somewhat of a corporate shakedown where the government is getting massive settlements for companies that just want to not be in the crosshairs, and they settle cases for, a couple $100 million, which, isn't particularly good for companies and shareholders. The argument would be that deterred bad conduct, and it certainly, I'm sure, it did. But the other side of it, it might have deterred opportunities for U.S. businesses to grow and thrive, not only overseas but also here.
Joe, you want to weigh in there? How are you affected by all this?
Well, I just, like John said, the FCPA was sort of ignored for about 30 years, right? And then they realized in the mid 2000s it was this like cash cow, and for 20 years we've seen aggressive enforcement. It's one of these things where, like, just when you take, your foot off the gas, you could see another administration coming in and coming, full bore again on it. So I would be very, very reticent to lighten up on controls. Maybe things like maybe not as much internal audit or something, but I would be very, very cautious. Yeah. It's a mature enough law that if corporations are not, keen on the FCPA by now, something's not right. But I would just be very cautious about letting your guard down in that respect.
And one real quick point, I know you know this, but it is a 5-year statute of limitations. So even if something occurs now and this current administration doesn't view it as within their priorities to look after, it doesn't mean if there's another administration, it might get a second look. And then you're in a position of saying we, detrimentally relied on their guidance, but the other side of it, well, the law never changed. The law remained the same.
Yeah, I also think that there's a backlash risk where, like, even if in fact there's not a huge chain in enforcement of things like FCPA, the fact that the Trump administration makes a big splash of doing less might make the next Democratic administration want to make a big splash out of doing more, and it sort of becomes this political football.
Well, the California Attorney General Rob Bonta actually announced that they would bring prosecutions under the unfair competition law in California. I don't know that they've actually done that before for foreign bribery, but it proves your point that what Trump does, the enforcers on the other side of the aisle will probably try to do the opposite.
All right, we have one more audience question we can fit in here before we jump out, and it's specifically to Jonathan Fahey. The question is, if the FCPA executive orders pause new enforcement actions, do we know whether companies who are currently subject to ongoing compliance regimes as part of the earlier settlement agreements are going to get those reevaluated?
I think that's part of what was in the order, that they want the current cases under investigation reevaluated. And if a company is under a DPA or something like that, it would be in their interest to get in front of this DOJ and to have it either reevaluated or renegotiated, however you want to discuss it, because these things can cost hundreds of millions of dollars. And if you go in there and say, hey, under this new policy, even though we even agreed to this 3 years ago, but under this new policy, you wouldn't enforce it. We don't think it's fair to have to pay this money or to be under some sort of monitorship or other things that may be burdensome to our company and our shareholders and everyone else.
Absolutely. My view is that everything pre-January 20th is at least potentially renegotiable. So if there's something you really need to be done, it's worth getting back in touch and trying to start on a clean slate. All right. Well, thanks everybody for your time, and thank you for the listeners. Thanks to Emily and the Federalist Society for organizing.
On behalf of the Federalist Society, thank you all for joining us for this great discussion today. And thank you also to our audience for joining us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for tuning in, and we are adjourned.